Hello, everyone. Welcome to the Fulgham Law Firm. I'm Jeff Hampton, an attorney with the Fulgham Law Firm, and thanks for joining us today on our YouTube channel. Today, I want to talk to you about how to beat a public intoxication charge in Texas. All right. And by the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a crime in Texas. Let's jump right into this. Okay, public intoxication. Now, listen, public intoxication laws in Texas can be a little vague and a little confusing. What I find a lot of times is when I talk to clients, people want to kind of superimpose DWI laws onto public intoxication laws because a lot of people have a general knowledge about what the law is related to DWI, and so they think that the laws are just basically the same or very similar. But I want you to understand, state law indicates that law enforcement officers under Texas law can arrest a person on suspicion of public intoxication. However, the law requires that the officer prove that that individual, because of alcohol, is a danger to themselves or another, right? That's what they have to show. Now, that's very vague. Let me give you an example of, I think, one of the most unfair examples of what police officers will sometimes do in Texas to people like this. One time we represented a woman who was a passenger in a vehicle being driven by a friend who'd been pulled over for suspicion of drunk driving. What does everybody tell you to do? Don't drink and drive. Have a designated driver. If you're going to drink, make sure someone else drives. Well, that's what she did, okay? The problem is the police pull over her friend, get him out, start doing field sobriety tests. Then they get her out and they say, okay, ma'am, looks like you've been driving, or looks like you've been drinking. Is that correct? Well, yeah, I've been drinking, but I'm not driving. I'm in the passenger seat here. I'm getting a ride home. Wow, but now it looks like you're in public. You're out here in the public. And now that you're in a public place, you appear to me to be intoxicated. Put your hands behind your back. You're under arrest. This happens all the time. People do not realize if you are pulled over for that person who's driving is pulled over for suspicion of driving while intoxicated, even though you have not been driving, if you may have been drinking, the police could still arrest you for public intoxication. So, a lot of times the second thing people will bring up to me is, well, yeah, but Jeff, they didn't do any field sobriety tests on me, and they didn't do a breath or blood test on me either. Well, in order to prove a DWI, they must do some field sobriety tests. And they really would need many times a breath or a blood test to prove that that individual has lost the normal use of their mental or physical faculties, or that they're over 0.08 in terms of the legal standard. The problem is, remember the difference in the law. Officers do not have to prove intoxication as defined by DWI law. They only have to prove that you're drinking, or whatever it is that they think is odd about you at that moment, is the result, is putting you or someone else in danger, okay? So they do not need breath tests or blood tests. They do not need you to do field sobriety tests if they don't want to. And so the bad thing about that is it leaves it open for kind of abuse. Sometimes officers will look at someone and say, I don't like your attitude. I don't like the way you're talking to me. Oh, did you have something to drink? Tell you what, buddy, put your hands behind your back. It's time for you to go to jail. Okay. I think you're a danger to yourself or others. Very subjective, just based upon suppositions. All right. That's all it is. So how do the charges work? Well, when we look at this, public intoxication is a Class C misdemeanor. Now, the good news is that means it is not punishable by jail time, but it is punishable only by a fine. The problem is if you get charged with public intoxication, they're going to arrest you. Because the moment they think you're intoxicated, you're going to jail. You go to the drunk tank, and then you have to bond out. So the problem is now you have an arrest record. So if the case is not handled properly, you could have a public intoxication arrest on your record for the rest of your life. That's the big difference. Even though it's just a ticket, it's a special ticket because there's an arrest associated with it, okay? So people ask me this question all the time, well, what can a lawyer do for me? Can't I just go in there and argue it by myself? You can, but here's what normally happens. If you go in there and you argue it by yourself, the prosecutor is going to usually say one of two things: pay the fine or go to trial. If you pay the fine, you're pleading guilty. That's what that means. So you don't want to pay the fine. And then they're not afraid of taking you to trial because you're not a lawyer. So you end up having these two choices. So a lawyer many times can do one of two things. The number one thing we try to do at the Fulgham Law Firm on a public intoxication charge, we want to get the evidence. We want to take a look at it and see if the state can prove the case. Many times police officers give very brief, non-specific details within their reports, and then they don't remember anything about the case later because they deal with these situations all the time. Sometimes it can just be flat out dismissed for sloppy reports, okay? Number two, you could sometimes get what's called a conditional dismissal, which means if you agree to pay a reduced fine, maybe not pick up a similar based offense for a certain period of time, 30 days, 60 days, then the case is dismissed. And here's the great news. Option 1 and option 2 are the same when it comes to you getting it off your record. You're immediately eligible to file for what's called an expunction. That allows you to remove all of these charges from your record. You can say for the rest of your life, nothing ever happened, okay? Finally, option 3, what an attorney can do for you is, if necessary, if you have an unreasonable prosecutor, you can take it to trial. And you can have an experienced lawyer who knows how to litigate these cases, take your case to trial to try to seek your exoneration. Now, I'm going to tell you this, especially if it's your first public intoxication, most of the time, overwhelming amount of time, we're able to do one of the first two options because we're interested in making sure and securing your opportunity to get this off your record. So now, listen, I've spoke very generally about this information here and about this charge of public intoxication. Maybe you or a loved one is facing that type of charge. Don't hesitate to contact the Fulgham Law Firm at 817-877-3030 for a free consultation. We'll be happy to talk to you about your situation and make sure that you're taken care of. Thanks again for joining us today on our YouTube channel. Look forward to seeing you on our next video series.